In my 20 years sitting on this bench, I have witnessed political pressure applied to courts in just about every form it takes. I have watched it arrive as a phone call from someone who did not leave a name. I have watched it arrive as a quietly worded letter, as a press release timed to a news cycle, as a suggestion delivered through an intermediary who wanted no record of the conversation. I have watched powerful people walk into rooms and expect the rooms to rearrange themselves. But never, not once in 20 years, did I open my docket on a Monday morning and find a formal petition for my own removal, filed by the sitting mayor of this city, released simultaneously to every television station in the county, 4 days after I ruled in favor of a city employee who had waited 18 months for a workers' compensation claim that should have taken 8 weeks. That petition arrived on a Thursday. By Monday morning, it was sitting on this bench in front of me, and the man who filed it was sitting 12 feet away, 5 terms in office, 20 years of walking into rooms and finding them already arranged to his satisfaction, about to discover what happens when a pressure campaign walks into a courtroom and the courtroom doesn't move. If you believe that a judge's job is to hold the line regardless of who is standing on the other side of it, stay for every word of this story. Because what happened next in this room will remind you that judicial independence is not a courtesy, it is the point. The gallery was full in a way I had not seen in 20 years. Every seat taken, standing room along both walls, the press section filled with reporters who had notepads open before I entered the room. My clerk met me at the door with the expression of someone who has been managing an unusual volume of phone calls since 7 in the morning and would like that to be noted. The docket entry read, Hargrove v. Municipal Court Administration, emergency petition for judicial removal, a filing number attached to a pressure campaign. I had read it 3 times over the weekend. I understood precisely what it was. Mayor Richard Aldrin arrived in a motorcade, 2 black SUVs, a city vehicle, 3 aides, a press secretary, and Victor Stahl, whose billing rate and client list are the 2 most widely discussed features of his professional reputation. What Aldrin did not do was enter the courtroom immediately. He stood in the corridor outside for 4 minutes, visible through the glass panel in the door, speaking to his aides with the unhurried confidence of a man who has decided that making a room wait for him is itself a form of communication. Several people in the gallery watched him through the glass. He was aware of that. When he entered, he moved directly to the petitioner's table without acknowledging anyone in the gallery. He did not look at the bench. He looked at the room. Instead, the cameras, the reporters, the City Hall staffers positioned along the back wall and appeared to find it satisfactory. He sat. He straightened his jacket. He opened a document folio that his aide placed in front of him. In the gallery's second row, a woman in a gray jacket sat with a cane resting against her knee and watched him settle into his chair. Her name was Delia Marsh. She had been waiting 18 months for a room to take this seriously. I called the hearing to order. Delia Marsh had worked for the city of Millhaven for 17 years, facilities supervisor, managing maintenance crews, coordinating safety inspections, the kind of institutional knowledge that takes a decade to build and is not easily replaced. She knew the city's buildings the way people know things they have spent years responsible for, not abstractly, but specifically, with the accumulated detail of someone who has walked every corridor and read every inspection report and written, on more than one occasion, the reports that other people were supposed to act on. 14 months before her injury, she submitted one of those reports, a city-owned building in her division. Structural concerns documented in writing, routed through the facilities department, received and logged. The facilities department did not act on it. The building was not inspected. The structural issue was not addressed. 18 months ago, the building failed. Julia was inside. The injury required 2 surgeries and left her with permanent mobility impairment. She filed a workers' compensation claim through the city's administrative process and waited. 8 weeks passed. 12. 20. The claim sat in a processing queue that Priya Anand would eventually document. through the city's own administrative records obtained under the Public Records Act, had been specifically configured to delay claims from employees in Delia's division, the division whose safety inspection records, if formally adjudicated, would surface reports the facilities department had received, logged, and chosen not to act on. The facilities department reported directly to the deputy mayor. The deputy mayor reported directly to Richard Aldrin. Delia waited. The queue held. And the building that had already failed once continued to appear in no active remediation record in the city system. Priyat Anand filed a motion to compel adjudication, and that motion is the reason this room was full that morning. I granted the motion to compel in 48 hours. The city's legal office requested a continuance, denied. They requested a second continuance, citing interagency coordination requirements, denied. The hearing was held. I ruled in Delia's favor on every substantive point, ordered the claim processed within 30 days, and noted in my written ruling that the administrative delay appeared to constitute a pattern rather than an isolated processing failure. I referred the matter to the State Labor Board for further review. 4 days later, Mayor Aldrin's office filed the emergency petition for judicial removal. It was released to the press on the same afternoon it was filed. Simultaneously, not subsequently. That timing was a decision, and it communicated exactly what it was intended to communicate. The petition cited 3 grounds: that my ruling demonstrated predetermined bias against municipal defendants, that my referral to the State Labor Board exceeded my jurisdictional authority, and that my denial of the city's continuance request indicated a failure to afford the municipality appropriate procedural consideration. Each ground was precisely worded. The document was the work of someone who understood that a petition of this kind does not need to succeed in court to succeed in purpose. What the petition did not name was the 19 other workers' compensation claims from Delia's division sitting in the same processing queue for an average of 14 months each. It did not name the 4 additional safety inspection reports submitted from the same building over 4 years, none of which had produced a documented response. And it did not name the internal email chain obtained by Priya Anand through a public records request the city had attempted and failed to delay past the statutory deadline, in which a senior facilities official asked how to handle the marsh situation and received a reply that read, "Same as the others. Let it sit." Priya placed the banker's box on the respondent's table before the hearing began. Victor Stahl rose, and he began to explain why I should no longer be sitting on this bench. Stahl's presentation was polished and precisely organized, the work of an attorney who has spent 2 decades constructing arguments designed to make institutional inertia look like due process. He led with the procedural bias claim, anchoring it to the continuance denials, arguing that the speed and decisiveness of my rulings demonstrated a predetermined disposition against the city. I let him finish. Then I asked my first question. "Mr. Stahl, the petition characterizes my denial of the city's continuance requests as evidence of procedural bias. The city requested its first continuance 48 hours before a hearing that had been scheduled with 21 days' notice. Can you identify for this court which specific procedural standard the denial is alleged to have violated?" He cited a standard by name. I asked him to locate it in the relevant procedural code and read the provision aloud. He found it. I asked him to read the section immediately following, the section specifying the conditions under which a continuance request submitted at that interval may be granted. He read it. The conditions were specific and enumerated. The city's request had met none of them. Stahl recalibrated without acknowledging that he had needed to. Then Priya Anand presented the record. 19 additional workers' compensation claims from Delia's division, average pending duration 14 months. The processing queue configuration documented through the city's own administrative records. The 4 safety inspection reports from Delia's building, each bearing a received and logged timestamp from the facilities department, none with a corresponding action record. The 14-month gap between the date of the final report and the date of the structural failure that put Delia Marsh in surgery. Then Priya placed the email chain on the record, and the room understood what the petition had been designed to keep out of it. The email chain was a single page. Pariah placed it on the record without commentary and allowed the courtroom to read it. A senior facilities official had written to the deputy mayor's office asking how to handle what the email referred to as the Marsh situation. The reply came from the deputy mayor's office the following morning. It was 5 words, same as the others. Let it sit. The courtroom read it in silence, the silence of a room that has just seen something stated plainly that everyone had suspected but no one had been able to document. Freya then presented the context for the word others. The 18 additional claims from the same division currently sitting in the same processing queue, each of them corresponding to an employee whose adjudicated case would produce inspection records, maintenance logs, and action histories from the facilities department. The others were not a backlog. They were not the product of administrative complexity or resource constraints or interagency coordination requirements. They were a deliberate configuration with a documented instruction at its center, written in plain language and sent in an email that the city had spent 47 days attempting to prevent from reaching this courtroom. Richard Aldrin's expression throughout was the expression of a man watching something he had constructed very carefully being taken apart with tools he did not know the other side possessed. The petition had been designed to make the morning about me. The banker's box had made it about the email, and the email made it about a question that only one person in the room could answer. Then I looked at Richard Aldrin, and I asked him the question. I asked it at the same volume I use for everything in this courtroom. No shift in register, no pause to mark it as different from any other question the morning had produced. Mayor Aldrin, I want to ask you something plainly. You have been the chief executive of this city for 20 years. The building where Delia Marsh was injured received 4 written safety inspection reports over 4 years, each routed to your facilities department, none of which produced a documented response. I am asking you to tell this court, at any point in those 4 years, did anyone in your administration bring those reports to your personal attention? Victor Stahl rose from his chair. I raised one hand without looking at him. I asked the mayor. Stahl sat. The room held completely still, the specific stillness of a space that has identified the moment it has been waiting for and collectively decided not to disturb it. What followed before Aldrin spoke was not the silence of a man composing his answer. It was the silence of a man discovering that the combination of language and authority that has functioned reliably in every room he has walked into for 20 years is not functioning in this one. He said the city processes thousands of inspection reports annually. He said he cannot be personally briefed on every facilities matter that moves through his administration. He said the question, with respect, falls outside the scope of a hearing concerning judicial conduct. He said his office would be happy to address any questions regarding administrative procedure through the appropriate channels. I told him what the question actually was. Mayor Aldrin, a woman who worked for this city for 17 years, was injured in a building that your administration had been told 4 times required attention. She then waited 18 months for a workers' compensation claim that your administration had specifically configured a queue to delay. I am not asking you about administrative procedure. I am asking you whether you knew, and I want you to understand that whatever your answer is, it will be entered into the permanent record of this proceeding. The room was completely still. Aldrin looked at Stahl. Stahl's expression gave him nothing. Aldrin looked at his hands. He looked at the wall above the bench. He did not look at me. He did not look at Delia Marsh, sitting in the second row in her gray jacket, with her cane against her knee, watching him with the particular patience of someone who has spent 18 months waiting for a room to ask exactly this. He said nothing. In a courtroom, silence of that kind enters the record as fully as any spoken word. I noted it. And then I issued my ruling. 4 parts. First, the petition for judicial removal is denied in its entirety. The cited procedural standards do not support the allegations made. and the petition's simultaneous release to the press at the time of filing is noted for the record as raising questions about its intended function. Second, the city is ordered to process all 19 outstanding workers' compensation claims from Delia's division within 45 days under independent administrative oversight. Third, the 4 safety inspection reports and the documented failure to act on them are referred to the State Attorney General's office for review of potential negligence liability. Fourth, the internal email chain is referred to the State Ethics Board with the full record of this proceeding attached. Mayor Aldrin's non-answer to a direct question regarding his personal knowledge of the inspection reports is entered into the transcript of this proceeding and will remain there permanently. Aldrin stood. Stahl placed a hand on his arm. Aldrin said in a voice still performing the authority of a man who controls rooms that his office would be responding through the appropriate legal and administrative channels. I said, Mayor Aldrin, every channel you respond through will have access to that record. He walked out. The motorcade aides fell into formation. The press secretary was already on her phone. Victor Stahl gathered his document folio with the practiced efficiency of an attorney who has escorted clients out of difficult rooms before and understands that how you leave is itself a communication. The courtroom watched him go. Delia Marsh did not watch him go. She was looking at Priya Anand. Priya Anand was looking at me. The State Attorney General's office accepted the negligence referral within 2 weeks and opened a formal investigation into the city's facilities management practices across a 5-year period. The investigation surfaced 11 additional city-owned buildings with unacted safety inspection reports on file. 3 of those buildings had experienced subsequent structural incidents. The AG's office expanded the scope of the investigation within 60 days of opening it. The State Ethics Board opened the parallel investigation into the email chain and the workers' compensation queue configuration within 30 days of the referral. The 45-day processing window produced results for all 19 claims. 14 claimants received full awards, 3 received partial awards, 2 received supplemental medical coverage beyond the scope of the original claim. Delia Marsh received a full award covering both surgeries, 18 months of documented lost wages, and a structured settlement for permanent mobility impairment. It did not restore what the injury had taken from her. It was what the process had always been designed to provide, and had not, until this bench required it to. 8 months after the hearing, Richard Aldrin announced he would not be seeking a 6th term. The statement was released through Victor Stahl, and like all statements of its kind, what it chose not to mention told you everything. It did not mention Delia Marsh. It did not mention the 4 safety inspection reports, the 19 claims, the 18 months, or the 5-word email. It said that after 20 years of dedicated service to the people of Mill Haven, Richard Aldrin had decided to pursue opportunities in the private sector. Victor Stahl had done what he could with the available material. The AG investigation concluded 14 months after the hearing. Its findings were referred to the county prosecutor on 3 counts: negligent administration of public safety obligations, obstruction of administrative process, and misconduct in public office. The deputy mayor, the person whose office had sent the reply, pleaded guilty to obstruction and received 18 months. Richard Aldrin faces trial. Priya Anand was appointed to the city's newly established Workers' Compensation Oversight Commission, the first independent body of its kind in Mill Haven's history. Every claim pending beyond 90 days is now subject to mandatory review. Her first act was to request a complete audit of the processing queue going back 7 years. Delia Marsh still walks with a cane. She attended the first public meeting of the Oversight Commission and sat in the front row. She did not speak. She did not need to. She had been waiting long enough. She was done waiting. I keep the email in the top drawer of my desk, not as a reminder of the ruling, as a reminder of what 5 words can build when institutional power decides that the most efficient response to a person in pain is to configure a queue and tell someone to let it sit. It does not get to sit, not in this room.